276, State versus Michael L. Porter. All right, we're on call 2014-276, State Mississippi versus Michael L. Porter. Mr. Porter, is that correct?
Yes, sir.
All right, Mr. Porter, you've been sworn in, so the answer you give will be sworn in on the penalty of perjury. Do you understand that?
Yes, sir.
You filed a petition to enter a plea of guilty for sexual battery is charged in count 1 of this indictment. In the petition, it indicates that your Social Security number is 428-65-6776. Is that correct?
Yes, sir.
Your date of birth is July 3rd of 87. Is that correct?
Yes, sir.
You finished 13 years of school, 4.5 years of college, and you're able to read and write. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol here today?
Yes, sir.
Have you ever been treated for any mental disease or disorder?
Yes, sir.
Did you read and sign your petition to enter a plea of guilty?
Yes, sir.
Do you understand everything in this petition?
Yes, sir.
Is everything in this petition true and correct?
Yes, sir.
Have you had an opportunity to discuss with your attorney all the facts and circumstances related to the crime that you offered to plead guilty to?
Yes, sir.
Did your discussions with the attorney include any possible defenses that you may have to this charge? Well, I believe I would now. Let me ask you another way. Did your discussions with your attorney include all the facts that you know of about the case? Those facts that might be helpful, harmful, everything that you know you talked to your attorney about?
Yes, sir.
Did your discussions with your attorney also include the elements of the crime?
Yes, sir.
Those elements are these as it relates to count 1. That on or about between October 1st of 2013 and April 15th of 2014 in Madison County, you being a male human being above the age of 18 years, your date of birth is July 3rd of 87, did willfully and lawfully engage in sexual battery as defined by law by engaging in fellatio with J.N., a female child whose age is at least 14 years but under 16 years, whose date of birth is June 10, 1998, at a time when you were more than 36 months older than J.N., all within Madison County. Do you understand those elements?
Yes, sir.
Do you understand that you have a right to be represented by an attorney at all critical stages of proceedings against you?
Yes, sir.
You also have a right to a speedy public trial by jury, and at that trial you be presumed to be innocent. Do you understand that?
Yes, sir.
Should you go to trial before you can be found guilty and sentenced, each of the 12 jurors would have to believe beyond a reasonable doubt that you're guilty before you can be found guilty. Do you understand that?
Yes, sir.
If you would go to trial, you'd have the right to confront and cross-examine all witnesses called to testify against you, and you'd have the right to subpoena witnesses to testify on your own behalf. Do you understand that?
Yes, sir.
You have a right to remain silent, which means nobody can force you or compel you to give evidence against yourself. Do you understand that right?
Yes, sir.
If you would go to trial, you'd have the right to either testify or not testify, and that choice would be yours. If you chose not to testify, and you asked me to do so, then I would instruct the jury that no adverse inference could be drawn by you exercising the right to remain silent. Do you understand that?
Yes, sir.
If you would go to trial and the jury's verdict would be against you, you'd have the right to an appeal. If you put forth the cost of that appeal, that cost plus the cost of your attorney would be paid for you by the state. Do you understand that?
Yes, sir.
Do you understand that by pleading guilty, you're waiving, giving up all these rights, and all those rights are set out in the petition?
Yes, sir.
Are you telling me then that that's what you want to do? You want to waive all these rights and proceed to plead guilty?
Yes, sir.
Do you understand the minimum maximum punishment can be imposed for the crime that you offer to plead guilty to?
Yes, sir.
Minimum period of incarceration is 0 years. The maximum period of incarceration is 30 years. The minimum fine is $0. And the maximum fine is $10,000. Does the state agree with that minimum maximum? understand that no maximum sentence?
Yes, sir.
Do you have any prior felony convictions?
No, sir.
So let me go back. Do you also understand that any sentence that you receive as a result of conviction of sexual battery must be served day for day?
Yes, sir.
Do you further understand that it would require you, once released, to register as a sex offender?
Yes, sir.
One of these things, do you still wish to go forward with your plea?
Yes, sir.
Do you have any prior felony convictions?
No, sir.
Do you have any other felony charges present in hand?
No, sir.
I need to talk to you about the status of a habitual offender. Habitual offender, someone's got 2 or more prior felony convictions. Should you ever attain that status and be charged, tried, and convicted as an habitual offender, then you'd be required to serve the maximum punishment authorized by law. Or whatever the offense may be, you have to serve the rate of 100% of day for day. Do you understand that?
Yes, sir.
And knowing that, you still wish to go forward with the plea.
Yes, sir.
What's about your basis?
Your Honor, between October 1st, 2013 through or until April 15th, 2014, this defendant did engage in a relationship, engage in sexual battery with a minor victim, which was J.N., birthday indicated in the indictment. At the time of this defendant, whose birthday also is indicated in the indictment, was more than 36 months older than he was.
Mr. Porter, do you have any disagreement with that factual basis?
No, sir.
Counsel, do you have any disagreement with the factual basis?
I have not.
Mr. Porter, has anyone used any threats, force, or intimidation to get you to change your plea from not guilty to guilty?
No, sir.
Has anyone made you any promises of leniency in effort to get you to change your plea?
No, sir.
After discussions with your attorney, are you the one that decided to plead guilty?
Yes, sir.
Are you telling me then that you're free and voluntarily admit you're guilty of this crime?
Yes, sir.
Are you pleading guilty because you're guilty for no other reason?
No, sir. Yes, sir.
Well, let me ask that question again, make sure that you understand. Are you pleading guilty because you are guilty for no other reason?
Yes, sir.
You understand that I'm not bound by any recommendation the state may make as to sentence, and instead I can impose a maximum sentence authorized by law.
Yes, sir.
And knowing that, you still wish to go forward with the plea.
Yes, sir.
Is there a claim for restitution?
No, Your Honor.
You understand that I accept your plea of guilty, that you will not have a right to appeal this conviction. You've been represented by Mr. Martin. Are you satisfied with his representation?
Yes, sir.
Do you have any complaints you wish to make about your attorney?
No, sir.
Do you have any questions about your rights, any questions about the crime that you are completely guilty to? What's the recommendation?
The state recommends a sentence of 15 years, with 10 years being suspended and the defendant being required to serve 5 years. After release, they be placed on 5 years of supervised probation, and the DA's office asks that they be monitored under the section 99-1984 of the city code, which allows for electronic monitoring as a condition of probation for sex offenders. The state also asks that there be $1,000 in investigative costs assessed to the original police department, $1,000 in investigative costs to the DA's office, and $1,000 fine payable to the Children's Trust Fund. As another condition of their probation, the state asks that there be no contact with the minor victim or immediate family in this matter. And also, as part of that, they would have to register as a sex offender and abide by all of those rules and regulations as required by law.
That's a different recommendation than is contained in the petition.
Yes, Your Honor. The state was contacted after the petition was filed by the victim's representative, and it was communicated to the DA's office at the victim's wish that this be the plea that was offered instead of the plea that was offered by the DA's office before the filing of their guilty plea petition.
First, I assume that the defendant has no objection to the change in recommendation.
No objection, Your Honor.
And Mr. Porter, was that the recommendation that you expected to hear?
Yes, sir.
And Mr. Martin, was that the recommendation as announced by the DA's office that you had received from the state? And it came to your client prior to us beginning this work? Yes, sir. So the bottom line, Mr. Porter, it's not too late at this point to stop this hearing and proceed to trial, but it will be once I accept the plea of guilty. So before I do that, I need to make sure this is what you want to do. Do you want to plead guilty?
Yes, sir.
Do you have any questions about anything?
No, sir.
You pled plea for crime of sexual battery is charged in count 1 of cause number 2014-276. Guilty or not guilty?
Guilty.
Counsel, you know the reason why this plea of guilty should not be accepted.
No, Your Honor.
What I find is plea of guilty is free and voluntarily, knowingly and intelligently made, and on a further finding has a factual basis. Therefore, I'm going to accept your plea of guilty, adjudicate you to be guilty of sexual battery that is charged in count 1 of this cause. The judgment and conviction will be entered against you. I don't believe there's a need for a pre-sentence report, but I'm going to delay sentencing here until I have both pleas, and we'll go through one sentence in here. So, counsel, you take it and keep it in the report with you. That's it. Next is cause number 2014-275, Blair Porter.
Testimony about this cause is oral.
All right, well, here for cause number 2014-275, State of Mississippi versus Blair Porter. You, Ms. Porter, is that correct?
Yes, sir.
Ms. Porter, you've been sworn in, so any answers you give will be sworn in under the penalty of perjury. Do you understand that? You filed a petition to enter a plea of guilty to sexual battery as charged in count 2 of this cause. And in the petition, you indicated that your date of birth is July the 12th of 87. Is that correct? Your social security number is 427-673948. Is that correct?
Yes.
You finished 13 years of school, 4 years of college, you're able to read and write. Is that correct? Are you under the influence of any drugs or alcohol here today? Have you ever been treated for any mental disease or disorder? Did you read and sign your petition to enter a plea of guilty?
Yes, sir.
Do you understand everything in this petition? Is everything in this petition true and correct? Have you had an opportunity to discuss with your attorney all the facts and circumstances related to the crime that you're offered to plead guilty to? Did you discuss this with your attorney, including any possible defenses that you may have with this charge?
Yes, sir.
Did you discuss this with your attorney also include the elements of the crime? Those elements of these as it relates to count 2. On or about between October the 1st, 2013 and April 15th, 2014, in Madison County, you being a female human being above the age of 18 years whose date of birth is July the 12th of 87, did willfully and lawfully unlawfully engage in sexual matters defined by law by engaging in cunnilingus with J.N., a female child whose age is at least 14 years but under 16 years, whose date of birth is June 10, 1998, at a time when you were more than 36 months older than J.N. Do you understand those elements?
Yes, sir.
Do you understand that you have a right to be represented by an attorney at all critical stages of the proceedings against you? You also have a right to a speedy public trial by jury, and at the trial you be presumed to be innocent. Do you understand that? Should you go to trial before you can be found guilty and sentenced, each of the 12 jurors would have to believe beyond a reasonable doubt that you're guilty before you could be found guilty. Do you understand that right? You would go to trial, you'd have the right to confront and cross-examine all the witnesses called to testify against you, and you'd have the right to subpoena the witnesses to testify on your own behalf. Do you understand that?
Yes, sir.
You have a right to remain silent, which means nobody can force you or compel you to give evidence against yourself. You understand that right? You would go to trial, you'd have the right to either testify or not to testify, and that choice would be yours. If you chose not to testify and you asked me to do so, then I would instruct the jury that no adverse efforts would be drawn on exercising the right to remain silent. You understand that? You would go to trial, and the jury's verdict would be against you. You'd have the right to an appeal. If you couldn't afford the cost of that appeal, that cost plus the cost of your attorney would be paid for you by the state. You understand that? You understand that by pleading guilty, you're waiving and giving up all of these rights, and all those rights are set out in your petition. Are you telling me then if that's what you want to do, you want to waive all these rights and proceed to plead guilty? Do you understand the minimum maximum punishment to be imposed for the crime that you're pleading guilty to? The minimum period of incarceration is 0 years, maximum period of incarceration is 30 years, the minimum fine is $0, and the maximum fine is $10,000. Do you understand that?
Yes.
Further, if you're convicted of this offense, any time that you're required to serve will be day for daytime. Do you understand that? And as also as a result of any conviction in this matter, you'll be required to register as a sex offender. Do you understand that? Knowing these things, do you still wish to go forward with the plea?
Yes, sir.
Do you have any prior felony convictions?
No, sir.
Do you have any other felony charges presently pending? I need to talk with you about the status of an habitual offender. Habitual offender is someone who's got 2 or more prior felony convictions. Should you ever attain that status? And if you're charged trying to get convicted as an habitual offender, you'd be required to serve the maximum punishment authorized by law for whatever that offense may be. And you'd have to serve the rate of 100% a day for day. Do you understand that?
Yes, sir.
And knowing that, you still wish to go forward with your plea. Let's back your basis.
On or between October 1st, 2013, through or until April 15th, 2014, in Madison County, Mississippi, this defendant did engage in sexual penetration with the minor victim, initials J.N., birthday indicated in the indictment, at the time when this defendant was more than 36 months older than the minor victim.
Porter, do you have any disagreement with that factual basis?
Yes, sir.
Counsel, do you have any disagreement with the factual basis?
I do not.
Or is anyone using threats, force, Are you pleading guilty because you're guilty for no other reason? You understand that I'm not bound by your recommendation stating we make as a sentence. Instead, I can impose a maximum sentence authorized by law. You know that you still wish to go forward with your plea. Is there a claim for restitution? You understand if I accept your plea of guilty that you will not have the right to appeal this conviction? You've been represented by Mr. Mark, and you're satisfied with his representation? Do you have any complaints you want to make against your attorney?
Yes, sir.
Do you have any questions about your rights and questions about the crime that you're also guilty to?
Yes, sir.
What's the recommendation?
State recommends a 15 years in custody with 10 years being suspended and then it being required to serve 5 years, then being placed on 5 years of supervised probation. Special condition of that probation that should be electronically monitored for statute 99-1984. Also, that she requires to register as a sex offender upon her release. She has no contact with minor victim or her immediate family. There's also $1,000 investigative cost to the original police department, $1,000 investigative cost to the DA's office, $1,000 fine may pay with the children's trust fund.
It's different than this contained in the petition.
Yes, Your Honor.
Same.
Same reasons indicated on this report.
All right. Ms. Porter, counsel, I assume you have no objection to the reduction of the recommendation. And Ms. Porter, was that the recommendation that you expected to hear? Counsel, although it's different than contained in the petition, was that the recommendation that you received and state communicated with the client prior to us beginning this plea?
Yes, Your Honor.
Bottom line, Ms. Porter, it's not too late at this point to stop this hearing and proceed to trial, but it will be once I accept your plea of guilty. So before I do that, I need to make sure that this is what you want to do. You want to plead guilty. Do you have any questions about anything? I do plead the crime of sexual battery is charged in count 2 of cause number 2014-275, guilty or not guilty. Counsel, you know of any reason why I believe guilty should not be accepted?
I do not.
Court, I find this plea of guilty is free, voluntarily, knowingly, and intelligently made, and are further finding as a factual basis. Therefore, we want to accept your plea of guilty, adjudicate you to be guilty of sexual battery is charged in count 2 of this cause. The judgment and conviction will be entered against you. I don't believe there's a need for a pre-sentence report. I'm prepared to go forward with sentencing. The state wishes to proceed in sentencing at both defendants the same time. Any objections from the defense?
No.
Okay. If we can, let's clear counsel table, please. All right, is there anything on behalf of the defendants that you'd like to present?
Your Honor, we don't have any further information to present to the board this time.
All right. Anything from the state?
Very briefly, Your Honor. We have John Stephen Paul, he told us to testify. Stand at the podium, Your Honor.
Over. You will state your name for the record.
My name is Keith Over. I'm an attorney representing the victims and the victim family.
And I'll hear anything you have on behalf of the victim's family relative to sentencing.
Your Honor, after careful thought, prayer, and due consideration, the plea recommendation has been reached with the approval and at the request of both the victim and the victim's family. And with that, we are on board with the recommendation set forth by the district attorney's office and have nothing further to run.
Right. Thank you, sir.
If I could ask a couple of questions, just to go before we step back to, away from the podium. Keith, there is,
If you can testify this, he's an officer of the court, you're away though.
Keith, during the course of this case, there have been several meetings between yourself, your clients, and the district attorney's office and law enforcement throughout this entire process.
That is correct.
And I know one of the things that we discussed many times was trying to craft a plea bargain that would result in the victim and the victim's family feeling that justice had been served in this case.
Yes, that was a consideration throughout this process. The DA's office has been in constant contact with my office, and the victim and the victim's family feel as though that justice has in fact been done for this recommendation of the DA's office.
And Chief, I know the recommendation that was posted today was lower than what was originally in the petition. Originally, the petition called for additional jail time. But that recommendation was changed today after consulting with you and your clients, and a recommendation was reached that was requested by the victim and their family. Is that correct? And based upon your communication, you feel that both the victim and the victim's family fully understand the recommendation, and again, that they are satisfied with the ultimate outcome of this case.
That is, and I believe they feel as though justice in fact will be so.
Anything further? No. Anything else from state? No. Anything further from the defense?
Nothing, Your Honor.
All right, Counsel, you will return the photo with those returns. All right. Relative to both calls number 2014-275 to Blair Porter and 2014-276 relative to Michael L. Porter. The sentences in each of these cases will be the same. I'm going to accept the recommendation of the state based upon consultation with the victim and the families. We discuss the report that each of you served a term of 15 years in custody of the Mississippi Department of Corrections. The last 10 years will be suspended. You will have 5 years to serve. You'll then be placed on 5 years supervised probation on and order supervision, specific conditions of which will be that you'll be electronically monitored as required or provided for by Section 99/1984. You'll have to register as a sex offender. Have those forms been signed and noticed?
We're working on it. We almost have them all.
Okay, I'm going to let you go ahead and do that before we finish sentencing. Council, while he's doing that, call the roll. All right, I'll place the copy of these in the file, though, the guilty, then the other copy will go with the sentencing order. All right, as specific further conditions of probation, you'll be required to pay each of you $1,000 investigative cost of original PD and the DA's office each, that you'll pay $1,000 with the Children's Trust Fund, and that each of you will pay court cost fees and assessments amount of
Mr. Porter's was $1,898.50. Mr. Porter was $1,498.
court costs. Mr. Porter's case, 276, will be $1,898.50, and Ms. Porter's case will be $1,498.50. Order that you pay these amounts are rated not less than $100 per month within the last working day of the first full calendar month after release from incarceration, and continuing from month to month thereafter until paid in full. Each of you during the period of supervised probation will have no contact with the victim, in this case, or the victim's family. Anything else on behalf of the defendants? Anything else to say? Please, substitute. Thank you.